page 1, of course, defines who can ask these questions. Page 2 defines in what situations they can inquire about the immigration status of a person. And the language says that a person's immigration status may be requested if they are, quote, lawfully detained for the investigation of a criminal offense.
Or arrested.
Right, or arrested. It's the or arrested part doesn't bother me nearly as much as the lawfully detained for the investigation of a criminal offense. I think we need to be very careful about defining what it means to lawfully detain a person for the investigation of a criminal offense. In the comments as you were laying out the bill, you said, you know, we won't get into a situation where we've got rogue officers who start repeatedly asking people for this kind of information because they could be sanctioned for failing to do their job. If their job is, of course, to enforce the laws of a municipality or the state or a county as the sheriff. But there's nothing in the bill that says that. And my concern is that if I'm an officer and I decide it's on my personal agenda to inquire into the immigration status of persons, I can think of reasons to lawfully detain them for the investigation of a criminal offense, as the language in the bill states. And if my police department, my superiors, realize that I'm kind of on a little bit of a mission here, and I'm literally making it my day-to-day mission to detain people for purposes of inquiring about their immigration status, I think it's going to be very hard for a municipality or a county or the state to say that the rogue officer can be sanctioned for failing to do their job, because I think if I'm an officer, I have a pretty good defense that I'm doing my job under the language as it's stated here. And I would like to be helpful in terms of making some clarifications to that language, if you would be open to considering that.
Of course, I'm glad to hear from you, and I'd be glad to consider any suggestions that you might have. What I would say is that the issue you raise is one of the discretion that we give police officers, and that is a separate issue from this bill. And that discretion every police officer has, but it is bounded by the requirement that they have probable cause, which Texas has a long and firm history of requiring probable cause before someone can be stopped and held for an investigation. And so there are others here who could testify to what's necessary for that. There are differences of opinion that are legitimate differences of opinion about what constitutes probable cause. But what I would suggest to you is that while I'm happy to entertain any suggestions you might have about strengthening the bill and making it a better bill, I think that it's also, from my time that I served on the Criminal Justice Committee and the 16 years that I've served in the legislature, it's very difficult to codify that discretion that you have to give officers in order for them to be able to do their job, because you just can't come up with every single circumstance. So my concern would be that I don't want to be overly prescriptive, and I don't want to make this any more prescribed than we do for any other issue, because the point here is that they have to have probable cause for a stop before anyone could be lawfully detained. There's no requirement here and no suggestion that they should be pulling people over to check on their immigration status.
Well, and that's the point of my concern. The language on lines 13 and 14 says that a person's immigration status, you can inquire about their immigration status if you've lawfully detained that person for the investigation of a criminal offense. Now, you know, arguably you could say lawfully detained means you had to have probable cause, but it's not defined in that way here.
I think that it is, not here but elsewhere. It is already a part of Texas law.
Well, it doesn't say lawfully detained as defined in code such and such, subsection such and such. What I'm telling you is I feel very confident as a lawyer that I could walk into a courtroom if I'm defending a police officer or a county officer, a sheriff, or a DPS official. I can make an argument that lawfully detained means a whole host of things. And when you lawfully detain someone for the investigation of a criminal offense, it doesn't even necessarily require by the language of this paragraph that the person be suspected of having committed a criminal offense. In fact, you could lawfully detain someone regarding the investigation of a criminal offense simply because you want to question them as a witness to a criminal offense. It doesn't even necessarily mean that the person you've detained has to be suspected of committing a crime. I think the language is incredibly broad, and it's going to provide a tool that probably is not your intention to provide, and I would just like to ask that we work together to make sure that if it is your intention, that it be very tight and that it only be used in those instances where there was probable cause to suspect that someone had committed a crime, that then the immigration status of the person would be inquired about.